I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today, for our 59th compilation video, we are going to be focusing on one judge, and that is Judge Victoria Shackleford out of the state of Michigan. I'm going to share some of Judge Shackleford's proceedings that we've had here on the channel. The last two compilation videos we focused on Judge Simpson, and we also focused on Magistrate Hillary Braley. If you want to check those out, you could just go to our YouTube channel and click on the compilation video playlist, and all of the compilations are there, including the ones that we're doing now, where we are focusing on one single judge. So with that being said, we will be in Judge Shackleford's courtroom for 4 previous proceedings, some classic moments. Before I get out of here, don't forget, no commentary will be at the end of this video, and also chapters will be added for your convenience. So guys, I'm ready. I'm sure you guys are ready. Let's go ahead and jump into Judge Shackleford's courtroom.
All right, this is 2301408 JP Morgan Chase Bank versus Arnold Chavez appearances.
Yes, Your Honor. Christopher Royce, P49102 on behalf of plaintiff.
All right, Mr. Chavez, can you turn on your camera and tell me your name?
Chavez Arnold.
There you go. All right, so last time we were here, the parties appeared, and I gave 10 days to submit answers to interrogatories. Were the answers to interrogatories filled out and returned?
Well, Your Honor, they were prepared. When I prepared for the hearing, apparently they were not sent. I did email them to Mr. Chavez this morning. However, the document production requests were, all documents were produced within days of the hearing, Your Honor.
All right, so Mr. Chavez, do you have all of that now?
No, like he said, I didn't. After 10 days, he just sent, I mean, I could check my email, but I haven't received anything from him.
Did you receive all the documents you requested?
No.
Mr. Royce, when were they sent?
They were sent on August 30th. Make sure that I'm...
No, we had a hearing on, maybe I have that on 10/24. We were waiting for answers to interrogatories.
Yeah, the interrogatories mostly related to whether there's compliance with the UCC and transfer of a note, and whether there was an assignment of debt, which of course there was not here.
Were all the documents submitted?
All documents, except for he had requested internal accounting records of Chase Bank, just generally, not specific. But the Chase Bank record relative to his account statements were provided.
Okay. So, Mr. Chavez, what is the defense on this case? What is your defense?
Well, I needed to see one of the documents. Well, my defense is that, you know, I've been researching the law and, you know, the powers of the banks, and it's more of a accuracy of the actual accounting that I'm trying to make sure, and, you know, make sure that everything is accurate. So it's not my intent to not pay anything, but I need to know, you know, based off the accounting, that I am paying what I'm supposed to be paying. And based off of what they're saying,
your last payment, I mean, back on 5/15/23, you owe $3,398.36. And they're coming for $3,398.36. I mean, that was the balance on the card at that time.
Like, that's why I asked questions, Your Honor. You know, you say you gave them 10 days to send it to me. They didn't send it to me. I just got an email this morning.
You're not disputing that you had the card, right?
But that's not the issue at hand, is what I'm saying.
No, it is the issue at hand. The issue at hand is, did you have a credit card? Did you use money on that card? And did you not pay the card off? That's the only question.
Right.
Those
So,
are the questions.
okay, my defense is I am the lender and they borrowed from me.
What did they borrow from you?
My personal security, which I'm
No,
entitled to rights to.
no, I'm not buying that. No. Listen to me. You listen.
It's not about, I have it. I'm going by the law, Your Honor. I'm not just making
No,
up
you're not
anything.
going by the law. You're making up the law as you go along. You took a credit card on. You agreed with that. And then you had a credit card. You used the credit card. You have a balance on the card and you didn't pay on the card. They don't owe you anything.
So so when I asked for the application, the evidence that opened up the account, because they go by GAAP accounting principles. If my application opened up the account, that means there will be a credit on my account because that's a cash equivalent. That's what the law says.
All right. Mr. Royce, I don't have a motion for summary disposition in the file.
Yeah, we talked about that last time and I was going to file one, but this hearing was a little bit too early. The motion would have had to been filed the next day. So I did not get that out.
All right, motion for summary disposition. We will have a hearing for a summary disposition on 1, 2, 3, 4, December 19th. Can I see that? 1 second. 1 second here. I have them.
No, wait a minute. December 19th.
Okay. It's gonna have to be January 9th.
Okay.
My clerk's indicating. So
I will get that out right away. I had it prepared, but then I noticed that I didn't have enough time to actually serve it.
Yeah, motion for summary disposition, hearing date will be January 9th to 25th. And the motions to be filed forthwith, and a copy obviously is to be provided to Mr. Chavez. And we'll see you back on January 9th, 2025 at 9:30 a.m. for the hearing.
Thank you, Your Honor.
All right, we're all set. All right, and I've got Mr. Chavez back. Do I have Discover Bank still?
Yes, Your Honor.
All right, Mr. Chavez, can you turn on your camera and your microphone, please, sir? All right, we're back on 24010674. The Discover Bank versus Arnold Chavez. Can I get appearances?
Good morning, Your Honor. Michael Goethals, P number 48992, of counsel to the law firm of Buckles and Buckles, appearing on behalf of Discover Bank.
All right, Mr. Chavez, tell me your name.
Chavez Arnold.
All right, and I know that we had a previous court date on this on October 10th, and the default was filed, and then an objection was filed timely on this case. So we're here to set aside the judgment. What's your motion, Mr. Chavez?
Well, that day, Xfinity, I have Xfinity internet, and it was working in my area. And I have proof of. I talked to them in the chat. They confirmed it, and I have they gave me a bill credit for the inconvenience, so that's why I wasn't able to attend because I was having problems with my internet.
All right, and just so you know, Mr. Goethals, we did have notice that he had contacted the court and that he was unable to get on that day.
Oh, he contacted the court on October 10th?
I'm not sure if it was on October 10th, but it was shortly thereafter. If it wasn't October 10th, that he was having internet issues and could not get on. So here's what we're doing. I'm assuming, Mr. Chavez, do you have a defense on this case?
I just want to go through the due process.
Okay. All right. Here's what we're going to do. I'm setting a date. So what do we need discovery on this? What, Mr. Gothal, so this is a credit card bill.
Yes, Your Honor, a Discover card.
All right, and this is Discover Bank, so there's no issue as to whether or not it's transferred hands.
No, Your Honor, we represent the original creditor.
All right, and I see there's an answer file. All right, this is an account stated under MCR 2.116, parent I. This court is making a ruling immediately based on the pleadings. The answer from Mr. Arnold indicates that he does not dispute that the card was taken out. The only dispute he appears to have is that a few paragraphs here, he does not agree with the fact that by virtue of defendant's default and breach, the entire balance of the account is now due, and these statements were attached, that the contract and or monthly statements are written instruments, evidence indebtedness with a specified interest rate, and that he disputes whether or not it's account stated. It clearly is. It's the original creditor. There's no sort of defense regarding assignment on this case. The balance at the time of the complaint was $4,378.29. Under MCR 2.116, parent I, parent 1, if the pleadings show that a party is entitled to judgment as a matter of law, or if the affidavits or other proofs show that there is no genuine issue of material fact, the court shall render judgment without delay, and the court is doing so.
Well, I have affidavits that support what I'm saying, but I will want to enter into this as evidence.
The motion for summary disposition is granted sua sponte by this court. There is no valid defense to this claim, and
I couldn't even enter any evidence.
And a judgment in the amount of what is claimed in the complaint, $4,378.29, will be entered by this court, and documents can be submitted for that purpose. And officer, I have a few more documents for that, and we're all set. All right, we're all set. Thank you, Mr. Arnold. Mr. Arnold, I have ruled against you.
I am allowed
to do so on the court rules. You filed an answer. It's the appropriate response to this. You're not going to make a mockery of the judicial system, which is what you're attempting to do. You're also not going to waste this court's time and resources on cases, on arguments that are invalid. I'm not wasting any more time on it. We are done. Thank you.
Thank you, Your Honor.
All right, Mr. Page, this is 242804, the City of Taylor versus Zachary Page.
And good afternoon, Your Honor. For the record, Matthew Zick for the people.
Okay, and I have a note on here. The people are requesting the case be set for a jury trial, and the defendant wants to fire the MIDC attorney. Is that accurate? Mr. Page, are you asking to represent yourself?
Yes, Your Honor. I'm representing myself.
Okay. Okay, you have a right to represent yourself, but I want to make sure you understand this, Mr. Page. You have a right to do that, okay? But you understand that attorneys go to law school and they study the rules of evidence. And if a person who is not a lawyer wants to proceed in a case, they're held to the same standard. You have to play within the same rules as a lawyer when you represent yourself. Do you understand that?
Yes, ma'am.
Okay, Mr. Page, I want you to see this. This is the Michigan court rules. This book is the rules that govern how we do trials, how evidence is admitted, how questions are asked, how trials proceed. And I'm going to assume you've not studied that book. Do you understand that if you go to trial and you represent yourself, that you will be held to the same standard and will be required to comply with those rules.
I understand.
Okay, is there anything else you want to put on record?
Yes.
All right, go ahead.
I, Zachary Page, lowercase a-h-a-r-y, P-A-G-E, a living man and one of the people of the Constitutional Republic of Michigan, appearing today sui juris. I am here under special appearance and under duress to address this matter. I am the beneficiary of the trust established by the U.S. Constitution and the Michigan Constitution, which operate as trust agreements. Under these trust agreements, public officials act as trustees and are bound by their oaths of office to serve the people, the beneficiaries. Their primary duty is to uphold and protect the inherent and unalienable rights of the people as mandated by these constitutions.
Okay, all right, Mr. Page.
I have more.
I know you can submit it in writing. I've heard it all before, sir. If you want to be a sovereign citizen today, that's fine with me. All right, but we're going to get through this court proceeding, and I want you to know you're going to behave at trial. You are bound by the laws of the state of Michigan, and that's how we'll be proceeding. So, sir, as to arraignment, how do you plead? You can plead guilty, you can plead not guilty, or you can stand mute.
Could you repeat the last part, please?
You could stand mute. That means you don't say anything and I enter a not guilty plea for you. So a guilty, not guilty, or stand mute.
I'm pleading not guilty to this.
Okay, I'll enter a not guilty plea on your behalf. Sorry, I have to go over a few things with you to make sure you understand them, okay? You're charged with interference with police authority. There is an allegation that on November 4th of 2024, while traveling southbound Telegraph near Brest Street in the city of Taylor, that you engaged in behavior that obstructed or interfered with police authority. That is the allegation against you. This is a misdemeanor. It is punishable maximum by up to 90 days in jail and a fine of up to $500. Sir, you have the right under the Constitution to have a trial by a jury and to have the assistance of an attorney. And you have a right to an attorney appointed at public expense if you are indigent, meaning you don't have the money to pay for an attorney. And if the offense requires a minimum jail sentence, there is no minimum jail sentence on this case, or the court determines it might sentence you to jail. It's my understanding that you have waived your right to a court-appointed attorney. You've already put that on record and you intend on representing yourself. You also have a right to a trial. And at that trial, you have the following rights: to call witnesses to speak for you at trial, and you can get an order signed by the court to require witnesses to come to court. You have a right to see, hear, and question all witnesses against you at trial, to be a witness for yourself or to remain silent. And if you chose not to be a witness on your own behalf, the prosecuting official may not comment on your refusal to testify. You also have a right to be presumed innocent unless proven guilty beyond a reasonable doubt. Those are your rights under the United States and Michigan Constitution. Do you understand what I just read to you, sir?
Yeah.
I'm not asking if you agree. I'm asking if you understand. And is that a yes?
Yeah, I understand.
Next we have Mr. Martin. Mr. Martin, sir, are you ready to be arraigned? Can you come up here, please?
Does Mr. Martin? this is 251756, the people versus Eric Martin. Mr. Martin, can you tell me your first and last name?
No, really don't want to give no name, so it's not fraudulent presumed on something else.
All right, well, I recognize you. You're Eric Martin. Sir, you've been brought to court on some charges here. Count 1 and count 2. The warrant alleges on June 12th of 2025 at property located at 9074 Clifford in the city of Taylor, a foreign complaint in this court was filed against you stating that on that date and location, the defendant, that's you, contrary to law, 1, did make an assault or an assault and battery upon the following person, Lisa K. Martin, contrary to MCL 750.81, parent 1. That's a misdemeanor punishable by up to 93 days in jail and up to $500 fine. He's already been arraigned.
Yeah, he's just.
Oh, so you know the original charges against you. And part of those charges against you, let's see, you could not have any contact with the complaining witness, Lisa K. Martin. You could not go to the address at 9074 Clifford. And you could not have any contact through the phone. You couldn't go in person. You couldn't go to the residence, period. And there's an allegation. I've got a report. You were arraigned on these allegations. It looks like on the 14th out county by Judge Burton. And then I have a police report that alleges on June 16th, officers were dispatched to that location. And there are allegations that you entered the residence through the back door and were actually in the home at time of arrest for violating your bond conditions. Those are the allegations against you.
Well, I move to dismiss the charges because the alleged bond conditions supposedly against me, which is really not against me anyways. Legal fiction, corporate entity, defendant, which does not mean I'm a living man. But anyways, besides that issue, the bond conditions violate my right to be presumed innocent before guilty. Because I am presumed innocent before guilty, any bond conditions violate my right. Because if I'm innocent, then I cannot be told you can't do this, you can't do that.
So, Mr. Martin, are you entering a guilty or not guilty plea on that violation?
First of all, I'm not a defendant, so I'm not here to enter a plea. How can I enter a plea? I'm not the one charged.
Okay, then I'm going to say you're standing mute. It's my understanding you've refused to meet with counsel. You don't want an attorney. So I'm entering a not guilty plea on your behalf.
So, okay, well, so have you made the legal determination that I'm not guilty?
No, sir. I'm doing it based on your arraignment. You understand the allegation against you. Do you? I just told you what it is. The allegation is you violated a condition of your bond on an assault and battery domestic violence case by returning to the address after being ordered you could not return to the address.
Well, like I said, I moved to like I said, bond conditions violate the right to be presumed innocent anyway, so that's no true bond condition violation is legit anyways. And there's no probable cause of this case. I should have been arrested illegally anyways because there is no evidence. My sister lied. Her allegations are a total lie.
All right, you have a right to remain silent. Anything you can say orally or in writing can and will be used against you, sir. You understand what the allegation is? You were just arraigned on it 2 days before picking up this, the original charge 2 days before picking up this violation. Mr. Martin, this is, I hear you. This is standard for you. And I honestly, you won't listen to court orders. You think they don't apply to you. You continue to go back to a residence you've been advised not to go to. You have a $25,000 cash or surety bond with a GPS tether.
Well, first of all, I don't have a choice. I have another house to go to for one. Besides, it's violating my
Well,
rights.
now you do. Now you do, Mr. Morton. You've got another house to go to now. It's
Yeah, well, guess what?
jail.
You
We'll
guys
see you
are
at your next
violating my
court date. All right, thank you, officer. We'll see you next time, Mr. Martin.
Goodbye, Mr. Martin. Okay, goodbye. Have a seat, Eric.
Okay, now we're on Eric Martin. This is 251756, the People versus Eric Martin.
Good morning, Your Honor. James Gazicki on behalf of Mr. Martin. Your Honor, he's waiving his right to a trial by jury, requesting trial by this court. And also, can I address bond, Your Honor?
Yeah, I signed the order granting discovery. Mr. Martin, you understand that you have a constitutional right to a trial by jury?
I comprehend that.
Do you understand that, sir?
I comprehend it. I just want to add, as I told him, I really don't consent to no jurisdiction of this court, but since I'm being forced to make the choice, I'm saying an Article 3 judge is going to be the choice, the forced choice. Article 3 judge.
Okay.
Even though the case shouldn't go, let me mention this too now. The case shouldn't go that far. We shouldn't be wasting taxpayers' money, nor my time in here. First of all, I proved my sister lying before on me with the same type of charge, Nessick, okay? I don't know the case number right now. I asked Jasinski to find out what it is. But in the same court, 23rd District Court, the judge is seeing she lied when I questioned her, did you swing at me before I kicked you? She answered no to that, and it was seen on the camera she lied. This is especially why I should not be made to wait on this.
Mr. Martin, you have a constitutional right to a trial by jury. Are you voluntarily waiving the right to a trial by jury?
Since I'm being forced to make
well, you're not being forced to make any choices.
Well,
you can have a trial by
so I am being forced.
Mr. Martin, listen, we can get through this, or we can go back and forth, and then I end up muting you, and then that's how we go forward. So let's see if we can do this without that, okay? You have a constitutional right to a trial by jury on this case. Are you waiving your right to a jury trial?
Yes.
And you understand that I'm the judge of the court, that I will be the trier of fact on your case?
Well, I want a motion for a judge trial, but I'm going to object to you being the judge based on past constitutional violations.
Okay, well, your motion for recusal is denied. So now, Mr. Martin, are you electing for me to try the case, yes or no?
In that forced sense, yes.
Well, you have two choices, a jury trial or me. Out of those two choices, which one do you like?
Are you an Article 3 judge?
Mr. Martin, I'm not going to entertain jurisdictional arguments. I'm asking you, do you want a trial by a judge or a jury? And I'm being very patient.
By a judge, I already said Article 3 judge. Article 3 judge.
Okay, well, I will be your judge. I've made that clear. This is a case I have jurisdiction over. It's a misdemeanor that's alleged to have occurred in the city of Taylor. So, so you're indicating to me that you're relinquishing your rights to a trial by a jury, and you'll be tried by me. And you understand, you've had a chance to talk to your lawyer about this, Mr. Martin?
Yep.
Okay.
I also want to make it clear, I have some other things to say. I enforce my right to a Republican form of government under Article 4, Section 4 of the U.S. Constitution. which is why the court don't have jurisdiction over me. And I am the third party beneficiary here. I am not the defendant.
Amy, can you find me
Despite the fraudulent presumption otherwise.
as possible? All right, give us a second, Mr. Martin. I'm trying to get your jury trial date.
We can even do on a state day.
I want to make clear, I'll point out, it's supposed to be 28 days and Saturdays and Sundays are not supposed to be excluded because the 28 days is specific for speedy trials and misdemeanors. And since that's specific under the court rules, it should be 28 days without excluding Saturdays and Sundays or legal holidays. That's made clear, I want to say, under the rule that dictates speedy trial, MCR 6.004C, and also MCR 1.103, the applicability rules that clearly says, where a rule is specific, it applies to that. So that the specific rules control over general rules.
Okay, Madam Prosecutor, how many witnesses?
I would say maximum 3.
Okay, Mr. Gazicki, how many witnesses?
Your Honor, first of all, I just want to put on the record that Mr. Martin in the past has not wanted my representation of him. Today, he says it's okay for me to represent him. I just wanted that on the record. I also advise Mr. Martin that his arguments that he makes about sovereign citizens and that is something that I can't follow, nor can I ask the court to follow it. Just so that's on the record. As far as witnesses goes right now, Your Honor, would say 1.
Okay.
Can we approach?
I mean, Mr. Gazicki's in the other room. Mr. Gazicki, can you come on in? We'll meet you in the back hallway. All right, Mr. Martin, 1 second.
Yeah, and I got something to say too while we get time in response to what he said. And for the record, the judge has abandoned court. This case is dismissed. I order this case be dismissed. Case number 25-1756-SM.
All right, we're going to set a bench trial July 14th in person at the 23rd District Court, July 14th at 10 a.m.
Your Honor, can we address bond?
You can address bond.
Okay, Mr. Martin requested that I ask this court if he can have a no condition type bond in this matter.
Okay, here's the problem. I'm just going to say it on the record. Request for a bond modification is denied. Mr. Martin had a very simple bond condition that he not go back to the residence. I know he doesn't think I can tell him that, but he's wrong. And he went back to the residence and got arrested again, allegedly, for being at the home when there was a no contact provision in place. So he clearly has a history of non-compliance. He doesn't think the court has jurisdiction over him. And the only way I can assure his presence and assure the safety of the community is to keep Mr. Martin in custody because he will not comply with my bond conditions. There's no such thing as an unconditional bond. So, okay, bond denied. And Mr. Martin, if you want to file motions that Mr. Gazicki legally could not file in good faith, feel free to file them. He's governed by court rules. He cannot file frivolous motions. So if you want to file more motions, feel free, get it, go at it. But Mr. Gazicki has indicated for the record, he will only be filing appropriate motions with this court. We'll see everyone back on the jury trial. That's my first date.
I have motions to make right now. I have some motions before we leave. I have some
Okay.
motions. Okay, and that is okay. Well, first, objection to what you just said, your statement about, there's no such thing as an unconditional bond. Yes, it's my right to be presumed innocent under the due process. The due process right, be presumed innocent before guilty. Because I am presumed innocent, that is why any bond conditions violate that right. So it
Okay,
violates
motion
that.
denied. What's your next one?
Okay, and I motion to dismiss because there is no probable cause. It is her word against mine. She's lying. She's been caught lying before, and there is no evidence at all. We have no case. There's no evidence, and that is not probable cause, as the U.S. Supreme Court said in Beck versus Ohio.
Well, it's a misdemeanor, so we're not having a preliminary exam. We're having a bench trial, and the prosecutor will have to prove the allegations beyond a reasonable doubt. And at that time, Mr. Martin, if at trial date, I assure you this. If you picked a bench trial. I was a practicing attorney for years. I promise you this. If she cannot prove her case beyond a reasonable doubt, the case will be dismissed.
Okay, but anyways, let me finish talking. I didn't finish talking about the motion to dismiss.
I know, but Mr. Martin.
As of right now.
What's your last motion? Do you have one more?
You haven't let me finish. You haven't let me finish the motion just based on no probable cause.
Okay.
As the U.S. Supreme Court said in Beck versus Ohio, or it was Ohio versus Beck, I forget which word is first, but the probable cause is defined as fact sufficient for the belief. Her word against mine. I told the cop she lied on me. Okay, her word against, we simply have her word against mine. That's all there is. So that's not fact sufficient for the belief. There's no probable cause now. The case should be, come on, let me finish.
Okay, denied.
The case should be dismissed now.
We'll see you back on your trial date. Have a good day. Okay. Thank you, Mr. Gazicki. That's it, right? All right, this is 2509380M, the People versus Randall Crain. We ready on Randall Crain? Mr. Crain's coming up. Hey, you, Mr. Gazicki?
No.
Mr. Crain, do you have counsel? Was that you, Mr. Barron?
Your Honor, Todd Barrett. I did speak with Mr. Crain prior to the court calling the case today. I think that at this time, Mr. Crain's probably best served proceeding is on his own. There are some constitutional arguments that he's raising that I don't think as a member of the bar I can.
Oh, is he a sovereign citizen?
He's making some sovereign arguments, yes.
Okay, I have very little patience for them. I will let you know that, sir. So, okay, tell me your name.
My name is Randall Crain. That's a living name, not a corporate fiction.
So you're a real person named Randall Crain.
Real person. Okay.
Okay, no, listen to me. Sir, you're here today because you have some charges against you. All right.
I'm challenging the court's jurisdiction.
Okay, well, denied. Your motion's denied. I have jurisdiction to the Constitution of the state of Michigan. What's your next? I'm not arguing with you, sir. I have jurisdiction. So
you have to provide subject matter jurisdiction as well as personal jurisdiction to me before these can proceed.
Okay, your motion's denied. I have jurisdiction under the Constitution of the state of Michigan. What else? What else?
You do not have jurisdiction over the national.
I just said I did.
No, you don't.
All right. All right. So, sir, do you want to proceed on these cases and talk to the prosecutor? Don't look on your phone while you're talking to me. If you
my notes are on.
No, you listen to me. If you don't know your sovereign citizen arguments well enough to come up here and say them, I can tell you can't have I can tell you can't have a phone in here. I want you to listen to me. You're here today on misdemeanor charges. No talking. You're brought into court. You've already been arraigned. You have a charge of interfering with police officers in the while they're doing official business. That's a misdemeanor, punishable by up to 90 days in jail and a fine of up to $500. You also have a civil infraction for operating using a mobile electronic device, first offense while operating a motor vehicle, a charge of no proof of insurance. Those are both civil infractions. civil infraction for no proof of or no registration in a motor vehicle. So those are the charges against you, sir. I'm going to tell you the rights that are actually real rights that you have in this court. You have a right to an attorney appointed at public expense if you are indigent without money to hire an attorney, and if the offense charge requires a minimum jail sentence or the court determines that it might sentence you to jail. The appointing authority will decide if you are indigent and appoint counsel if you are eligible. You may have to repay the expense for an appointed attorney. You may contest your ability to pay the ordered fees if the court attempts to collect any cost for an attorney, and the court must determine your ability to pay at that time. If you have a trial, you have the following rights. You have a right to, this is how trials work. You have a right to call witnesses to speak for you at trial, and you can get an order signed by the court to require witnesses to come to court. You have a right to see, hear, and question all witnesses against you at trial. You have a right to be a witness for yourself or to remain silent. If you chose not to be a witness on your own behalf, the prosecutor could not comment on your refusal to testify. Lastly, you have a right to be presumed innocent unless you are proven guilty beyond a reasonable doubt. If you enter a plea, obviously you'd be waiving those rights. You also have a right to be released on bond. Now, it looks like you previously stood mute on these charges, so you're here today for a pretrial. You have a few options, sir, under the law of the United States, the Constitution of the state of Michigan, and statutory law and court rules in the state of Michigan. You can either retain your own attorney to proceed on this case, or you can have a pretrial with the prosecutor directly and try and work out an agreement, or we can set it for a jury trial. Okay, those are your options. You can get an attorney, use a court appointed attorney, but you understand that attorneys have an obligation to follow the law and not make frivolous arguments, which is what you want to make today. And if an attorney makes those arguments on your behalf, I could sanction them. So no attorney on this green earth is going to come in and make the frivolous arguments you're making on your behalf. Or you can speak to the prosecutor, or we can just set it for a jury trial. Out of those, I don't want to hear it. I want you to pick out of those four options what you want to do. Hire an attorney, speak with court appointed attorney, talk directly to the prosecutor to work towards a resolution, or set a jury trial. Pick.
Let me ask you a question.
No, I asked you a question and I'm telling you to answer it.
And I have the right to understand my rights and understanding.
Sir, here, can you hand him this form? These are your constitutional rights I just read to you. Why don't you have a seat? You have a seat, read your rights, and I'll call your case back up.
I am asking for you.
Have a seat right now and read your rights.
Office.
Have a seat.
Have a seat right now and read your rights, sir. If you don't understand them, read them.
I move for this court to dismiss. Have a seat.
Okay, next case. All right, we're coming back up. This is 2509380M, the City of Taylor versus Randall Crain. Mr. Crain, you want to come back up? Mr. Crain, did you have a chance to go over your constitutional rights that I provided to you?
Yes, I understand my constitutional rights.
Okay, thank you, sir. So at this time, I gave you four options. Would you like to retain your own attorney? Would you like to speak with House counsel and have an appointed attorney? Would you like to meet directly with the prosecutor? Or would you like to set the matter for jury trial?
I'm going to be requesting for an order of change of venue.
Denied. Anything else? There's no basis for that, sir. So I'm asking you, we'll just set it for a jury trial, okay?
I have to understand everything in regards to my case.
Sir, I gave you your constitutional rights so that you could review them. I also gave you the attorney, a court-appointed attorney to go over those rights with. So I gave you an opportunity to understand your rights. I'm not going to entertain, listen, I'm not entertaining your sovereign citizen arguments because they're unfounded and they're not legal. There's no legal basis for them. So I'm not doing it. So now I'm asking you, out of the four choices I gave you, which one would you like to do?
I am required to understand everything in regards to my case,
Okay.
including subject jurisdiction matters.
All right, well, you could do your
Personal
research. I'm
jurisdiction.
setting this for a jury trial. We'll see you back for your jury trial on November 14th of 2025 at 9:00 a.m. I really recommend you retain an attorney prior to that date, sir, because I know I'm going to tell you what you're not going to do: waste the citizens of Taylor's time with your nonsensical arguments. You're going to come in, you're going to try your case. Again, if you want to talk to House Counsel, you could do so. All
I'm
right.
not wasting the city of Taylor's time.
Okay, good. We'll see you on your trial date. Have a good day.
I'm not threatening you. Say one more word and that's 30 days. 30 days.